Jenny likes to be in there. Yeah. She helped me prep for an argument at later. All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. It's nice to see students from the University of North Carolina International Exchange Program arguments today. I want to recognize Rebecca Howell, the UNC Director of International Programs, Professor Donna Nixon. Good to have you. And all the students who are visiting from Germany, Spain, United Kingdom, and France. Warm welcome here to North Carolina. Our next case is State versus Lester, and we will hear from the appellant.
Good morning. May it please the court, my name is Heidi Williams. I'm here from the North Carolina Department of Justice. Seated with me at council table is Tiffany Lucas. She's Deputy General Counsel at the North Carolina Department of Justice, and together we represent the state as the appellant in this matter. At this time, I would like to reserve 5 minutes for rebuttal. This case raises an important question regarding the scope of the constitutional protections afforded under the Confrontation Clause. The Court of Appeals below held that the admission at trial of computer-generated cell phone data violated defendants' constitutional rights under the Confrontation Clause. However, as recently as earlier this year, the United States Supreme Court once again reaffirmed in Smith versus Arizona that the Confrontation Clause applies only to a particular category of evidence, testimonial hearsay. Data generated by a computer is not hearsay because it is not a statement made by any declarant or witness against the accused, and such data is not testimonial because it is generated automatically by a computer. Because the Court of Appeals in its published opinion improperly expanded the scope of the constitutional protections under the Confrontation Clause to an unprecedented and improper category of evidence, the state asks this court to reverse the lower court's decision and to remand this case back to that court so it can address defendants' remaining issues that were raised on appeal. To begin, cell phone records generated computer are not statements by any witness. In State versus Smith, not too long ago in 2022, the Court of Appeals addressed a very similar issue to what is in front of this court today. The court addressed whether date and time stamps on a recording constituted hearsay. The court there first drew a distinction between computer-stored and computer-generated records, which it explained depends on the manner in which the content was created by a person or machine, and the court defined computer-generated records as those that represent the self-generated record of a computer's operation resulting from the company's programming. The Court of Appeals found that such records, by definition, do not contain statements from any person and therefore do not implicate hearsay concerns. Here, the records that were admitted by the trial court in States Exhibits 2 and 3 are very similar to the records that were addressed by the Court of Appeals in State versus Smith, in that we're dealing with cell phone data that demonstrates the dates and timestamps for calls made between the cell phone number associated with the defendant and associated with the victim. Numerous other jurisdictions have agreed with what the Court of Appeals held in State versus Smith. In the state's brief on appeal, we cited case law from the 2nd, the 4th, the 5th, the 7th, the 9th, the 10th, the 11th federal circuit courts that all addressed similar issues about whether or not, when we're dealing with data that was generated by a computer, does that implicate hearsay concerns? All of them held that when that data is generated by a computer, it doesn't fall within the protections of the Confrontation Clause. The state also directed this court's attention in its briefing to State versus Ortiz-Zape. I hope I'm pronouncing that correctly. But that was a 2013 case by this court where it addressed the use of substitute analyst testimony. And although the legal issues before the court here and in the Ortiz case are not directly on point, this court did provide analysis in that 2013 opinion that is informative here on the idea that when data is generated by a computer, that is not hearsay and does not implicate the Confrontation Clause.
Before you go any further, I wanted to ask you, I mean, I think both parties in this case are sort of looking at the question of whether or not this raw data is statements or testimonial. But one way you could read the Court of Appeals, I'm just curious your take on this, one way to read what they were saying is that they weren't disputing the legal principle that if you have raw data that's generated by some algorithm, that would not create Confrontation Clause problems. But that here, the state didn't show as a factual matter that this was raw data. In other words, I guess meaning that conceivably the information, that digital information, could have been some human being sitting there and putting it all into that spreadsheet, and that the state just didn't meet that evidentiary barrier to show that it was raw data. So what's your response to that?
So my response, Justice Dietz, and again, how you read the opinion, your interpretation of what the Court of Appeals said, that's not quite how I would view the Court of Appeals opinion. And
I'm not sure it's how I view it either, just to understand. I just am trying to understand what they meant when they were saying that.
From my reading of the Court of Appeals opinion, I didn't read anything from the opinion that said that their application of the Confrontation Clause was hinged on some kind of theory that the state failed to prove that this was, in fact, computer-generated data. And I think the breadth of the Court of Appeals opinion here, just saying we're dealing with cell phone records, those are implicated under the Confrontation Clause. I think the scope of its analysis in the opinion is problematic for future cases. And at least that is my reading of that opinion.
Well, so I am trying to understand the limits of the argument that the state is making here, because you're saying that these records from Verizon are not hearsay, so they're not governed by the business records rule, so there's no need to authenticate it. There's no need for anyone to come in and say, I work at Verizon, and these are the records we keep in the ordinary course of business, and the numbers that are on this sheet, however it's received, but on this sheet of paper are generated by us, and these are actually the phone numbers. There's no need to do any of that because they're not hearsay, so they're not business records. How does that not? The notion that because they're machine generated, they're no longer statements, so they're no longer hearsay. How does that not open up a huge door to all sorts of information being presented without the kind of authentication and indicia of reliability that the business records requirements establish?
Justice Earls, that's a good question. And I want to clarify that the state's point is not that these kind of computer-generated data records don't have to be authenticated. They just don't have to be authenticated in the way that is required under the hearsay exception, so 803 subsection 6. But the state is not making an argument that, in general, when a proponent of evidence offers such evidence like these kinds of records, Rule 901 governing authentication, that's how you would evaluate whether or not this kind of information should or should not come in addition to the other rules. Is it relevant? So the state doesn't, in these kinds of situations generally, Rule 901 is what will govern the authentication of the records. The issue here is that defendant in the trial court never raised any kind of objection to this evidence under Rule 901. And in fact, in his briefing before this court, has conceded that authentication, so even if the question here is, okay, this evidence doesn't fall under the confrontation clause, was it nonetheless admissible? Well, then the next question is, okay, well, was it properly authenticated at the time it was admitted? Defendant has waived in his briefing before this court that authentication is simply not an issue. He's conceded that he's not disputing that the records were authentic, and that comes from page 28 of his brief, where the defendant states authenticity has nothing to do with the issues at bar. Mr. Lester has not argued that the Excel files which the state produced in States Exhibit 2 and 3 are not what the state's own evidence purported. An Excel file which resulted from a series of transactions, that someone from Verizon took its raw data, created a record of unknown file, which someone at the police station downloaded, which someone at the police station then ran through the PLX program, using some undefined standards of relevancy to eventually produce the Excel files, which were then introduced and printed out for trial. So defendant here has waived the issue, has conceded that these are authentic records and that authenticity is not an issue. However, Justice Earls, you are correct that in a typical case, if this kind of raw data is not hearsay, the proponent of the evidence would still generally have to show, if it was challenged at all, that these records were authentic under Rule 901.
Well, I didn't understand the defendant to be, so the Court of Appeals opinion found both that there was a confrontation clause problem and that these records had not been properly authenticated under the business records exception to the hearsay rule.
Correct.
I didn't understand the defendant to be waiving, not supporting that second part of the Court of Appeals opinion.
Well, again, Justice Earls, that comes down to the analysis for what is required to authenticate business records under the hearsay exception in 8036 may be different than what is required to authenticate business records that are not hearsay under Rule 901.
Well, I'm struggling with your assertion that they've waived authenticity, but they're still maintaining that they were not properly authenticated.
So I guess my position is that they have waived authenticity for purposes of 901, but they are still continuing to maintain that these records were not properly authenticated under 8036, but 8036 doesn't apply here if the evidence, if the data is not hearsay to begin with.
But did the state say at trial, we're not offering these as business records, because there was an objection at trial on this question of whether they were properly authenticated. At that point, did the state say, well, Your Honor, we're offering these under Rule 901, and that's the rule that applies?
Your Honor, the defendant objected based on the hearsay exception, the business records. So the defendant did not object based on 901.
Right, but the state didn't say we're offering these. In other words, was the defendant on notice that that was the state's position, that these should be considered under Rule 901? And was the trial court?
No one discussed Rule 901 at the trial court proceedings.
So just to confirm, there's no evidence in the record you can point to that would demonstrate that under Rule 901 that these documents were authentic.
So that is not accurate, Justice Riggs. So I think there is evidence in the record that even under Rule 901, this evidence was properly authenticated. And I would direct this court's attention to the testimony of Detective Armando Bachi, and that's at page 410 through 411 of the trial court transcript, where Detective Bachi testified that the victim reported that, quote, there were communications between them by phone and voice and texting, end quote. He was then, quote, verbally provided both phone numbers, end quote. Bachi then, quote, sought to obtain the call detail records to verify the link between the two. He explained, I have to obtain a court order signed by a superior court judge requesting the information from the cell phone provider that they then send us for a given time frame. Bachi then explained that Verizon sent him the records electronically in a secure format, and he then forwarded those to the cyber intelligence unit. And then on pages 315 to 316 of the trial court transcript, Detective John Snyder, who is part of the cyber intelligence unit, described the process of receiving the secure link from Verizon, of downloading the data from that secured link, then putting the data through the PLX program, to pull the data that only related to the cell phone numbers associated with the victim and the defendant in this case. And I would direct this court's attention to State versus Wilson, which is 313 NC 516, a 1985 opinion from this court where it held that authenticity of records may be established by circumstantial evidence. And this opinion was cited then by the Court of Appeals in State versus Crawley. The citation is 217 NC App 509, a 2011 case where the Court of Appeals, citing Wilson, held that a detective could sufficiently authenticate a defendant's cell phone records under Rule 901, where he testified that he received those records from the cell phone company pursuant to a court order, which is exactly what we have here.
Do you perceive a distinction between the nature of the machine-generated records in Exhibit 2 versus Exhibit 3? And in particular, in Exhibit 2, the creation of which cell phone number called which cell phone number at what time happens entirely by the computerized processes at Verizon, whereas the second exhibit involved a human person telling a software program to do certain things, and that there's a human element to the data that then is produced. And I raise this because when I type a paragraph on my computer, the computer generates a piece of paper with the paragraph on it, so it is machine generated, but I had a lot of input on it. And it would seem to me that if I type out a statement, a paragraph on a piece of paper, just because my computer printed it out doesn't mean it is no longer hearsay.
Your Honor, that's a great question. And the state's position on that point is that there should not be a distinction for Confrontation Clause purposes drawn between State's Exhibit 2 and Exhibit 3, because the data in both exhibits is the same, identical, regarding the information regarding the defendant's cell phone number and the victim's cell phone.
What about a distinction for the purposes of whether one is hearsay involving statements, essentially statements made by the person who tells the software program what to do, so for hearsay purposes rather than Confrontation Clause purposes?
For hearsay purposes, Your Honor, the state's position is the same, that the data in the exhibits, all of the data in Exhibit 3 is also found in Exhibit 2. The only difference between the two is that the data in Exhibit 2 is the larger set identifying every communication made between the defendant's cell phone number and every other cell phone that he was in contact with between the period of May and July of 2019. Exhibit 3, the only difference is that they just pulled the smaller data set from Exhibit 2 regarding the phone numbers that pertain to the defendant's and the victim's cell phone numbers.
Right, but someone had to tell the program to make those distinctions, right? And to decide which data to show and not show.
Your Honor, the state's position is that the reorganization of the data, if it did not change the nature of their underlying data itself, does not transform that data into a statement by a declarant.
And then how is that distinct from my computer paragraph example?
Your Honor, so in our case, right, there's a way to verify that the data from Exhibit 3 is also encompassed in Exhibit 2, and it's just by comparing it. And you can see it. Whereas in those circumstances, there never is a human declarant who is creating something new. So the computer generated the data, which is the dates, timestamps between cell phone numbers. That information is contained in Exhibit 2. A smaller subset of that exact same information is in Exhibit 3, compared to your hypothetical, where a human actor is creating the information that the computer then prints out. So that would be, the example you provided would be akin to the computer stored data, which the Court of Appeals referenced in Smith.
So is your position basically that if you take a set of non-statements and all you do is take some of those non-statements out, that doesn't turn them into statements?
Correct.
They're still non-statements.
Correct. That's exactly right, Justice Allen. I would like to direct the court's attention just briefly to United States Supreme Court case law and kind of how that interacts with the state's argument here, particularly because State versus Arizona is such a new decision by the United States Supreme Court. So the defendant in his brief before this court analogized this case to a 2011 decision by the United States Supreme Court, Bullcoming versus New Mexico. The state attempted to distinguish that case in its reply brief, but I'd like to address that again just briefly here. So in Bullcoming, an analyst tested a blood alcohol level of someone charged with drunk driving and prepared a quote-unquote testimonial certification reporting that the level was higher than legal. Then at trial, the state called a different analyst from the same lab to testify as to what the certification said, and the United States Supreme Court held that, quote, surrogate testimony of that order does not meet the constitutional requirement. I think it's very important that in kind of the line of U.S. Supreme Court case law, so you have Melendez-Diaz versus Massachusetts, and then Bullcoming, and then Williams versus Illinois, and then Smith versus Arizona. All of that case law dealt with substitute analyst testimony where the initial analyst wrote some kind of report or came to some kind of conclusion that was then referenced by a substitute analyst at trial. And in Bullcoming, in a concurring opinion, Justice Sotomayor specifically highlighted some of the scenarios that were not present in that case. And she specifically mentioned instances where the state, quote, introduced only machine-generated results, such as a printout from a gas chromatograph. So she even highlighted there that these opinions dealing with substitute analyst testimony, it's not the legal issue before this court, because here we're dealing with the underlying data. And then I think that goes back consistently with what this court held in the Ortiz opinion, where it identified that in that case, the substitute analyst relied on the raw data from the lab machines in order to form her opinion. And nothing in any of the subsequent U.S. Supreme case law has drawn that kind of analysis into question. Briefly, the state's position on the confrontation clause, many of the arguments the state made regarding that also apply to the hearsay issue. Again, it's just the argument that because these documents are not statements by any declarant, they don't fall within the confrontation clause, nor do they qualify as hearsay. In addition, the state would point out that for purposes of prejudice, even if this court were to conclude that there was some kind of error, either constitutional or evidentiary, the state's position is that the testimony of this victim, a 13-year-old girl who was sexually assaulted, standing alone, she described in detail the actions of defendant against her. She identified him at trial, and that her testimony was also corroborated. Some of the details surrounding her testimony was corroborated by her brother, by her father, who both testified at trial, and that her testimony standing alone would be sufficient to support these convictions, and that whether we're looking at this under a constitutional error standard or if this court concludes that there was no constitutional violation, but perhaps there was some other evidentiary violation in the admission of the data, that any error in that regard would be harmless in light of the victim's clear and unequivocal testimony regarding the crimes that she endured, that she provided at trial. Unless the court has other questions, I will reserve the remainder of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
May it please the court, my name is Mark Hayes, and I represent the appellee, Mr. Lester. The state's argument is premised on a very simple contention, a contention of fact, and I think Justice Dietz sits on this. It's just a question of, are these in fact computer-generated records? Says who? Well, the state says that it is. It's their burden to show it. It's their burden both as the proponent of evidence. It's also their burden separately as trying to get in evidence against the confrontation clause once it's been objected to. So we can look at these exhibits and we start by saying, okay, well, they are Excel files. And as Justice Earls, I think, hit on, just the them being computer files doesn't say they're computer generated. This court, produces its opinions in Word. Back when I was clerking here, it was Word perfect. I mean, they're not computer generated, right? Y'all are writing those things. It has to do with, the state's own definition. Was it self-generated, resulting from programming? Obviously, y'all's opinions are not generated from programming, and they're not self-generated. So what are the sources of information that we have on this record about whether these exhibits are computer generated or not? We don't have a lot. We first have Officer Schneider, who testifies, and we have Officer Bakke, I think it is Bakke. The two of them together explain how Officer Bakke submitted a request, got a link from Verizon, forwarded it on to Officer Schneider, who downloaded a file from that link, and then ran it into the PLX system and generated ultimately exhibit number 3. Finally, we also have the cover page of exhibit 2, which is ostensibly from someone named Matthew Griffin. Of course, the problem here is we can't be using evidence that violates the Confrontation Clause to establish that, something else is not violating the Confrontation Clause. But if we take a look at that letter, just interestingly, it actually says the attached digital files of records are true and accurate copies of the records created from the information maintained by Verizon. So if you take this at what it's worth, which again, I don't think you can really take this letter since it itself violates the Confrontation Clause, it's saying that Verizon has information somewhere. What is that? Is that an Excel file? I find it remarkable that Verizon, a company of that size with that much data, would use the same program that I use to balance my IOLTA account. I'm sure it wasn't an Excel file, something else. So there's information somewhere. What is it? How is that created? Is it created by computer? We could surmise that it was. Is it exclusively created by computer? We don't know. That information was then used to create records. What are those records? Was that created by computer? Is there a computer program that's spitting out Excel files up at Verizon? We don't know. Computer, person, we don't know. Then we get to level 3. We have copies of that, which are called accurate copies by the letter, which again, itself violates the Confrontation Clause. So we don't know, was that copy created by a person, created by a computer? We don't know. It then gets put on a link. We get down to level 4. Level 4 is the thing that is actually downloaded by the police. And the officer does testify, here was this link, I downloaded it. That is the only concession on authenticity that I make. That was authentic. He testified that that's what he downloaded. We don't quibble with that. It is embedded on so many levels above that with stuff that we do not know where it came from and what it was created by. And we certainly have not waived or agreed that that's the case. Thus, we have 2 exhibits.
Is there any significance in the letter you referenced from Mr. Griffin, where in number 2, the document says that it's Verizon's ordinary practice to maintain such records, and the said records were made contemporaneously with the transaction and events?
I would have 2 things in response to that. First of all, again, the letter, we can't use it because it itself is violating the Confrontation Clause. Mr. Griffin doesn't appear. But let's bear down a little bit into that. I think your question might be, what if we could show that it is really reliable, right? That it's accurate. We know. An angel comes down and touches it on the nose and says, this is right. Does that cure it? I direct the court to this excerpt from Melendez-Diaz, which is quoting Crawford. To be sure, the clause's ultimate goal is to ensure reliability of evidence, but it is a procedural rather than a substantive guarantee. It commands not that the evidence be reliable, but that reliability be assessed in a particular manner by testing in the crucible of cross-examination, dispensing with confrontation because testimony is obviously reliable, is akin to dispensing with jury trial because the defendant is obviously guilty. This is not what the Sixth Amendment prescribes. So if we take that letter at absolute face value, It's 100% reliable. That still doesn't fix it because we don't know who created it. And the inference that was created by a computer is not supported by evidence.
So that's what I was trying to understand. So who in your view is it that the state should have called that your client could have confronted at the trial?
Well, it's hard to say because, of course, none of this was argued at trial. State doesn't bring any of this up. So obviously they didn't build a record, and that's why we're where we're at.
But wouldn't it have to be, if you kind of follow your logic,
Right.
I mean, let's assume that we can accept that this is computer generated in the sense that this is not, there's no one by hand tracking it for Verizon's information about when cell phone calls are being made and somehow entering it into a computer. So if it is all just an algorithm, wouldn't the only person that you could confront be whoever programmed the algorithm? I mean, that's how you would try to challenge whether or not the information that it's automatically gathering without any human input is gathering the right information. And that, it seems to me that's a pretty far stretch from looking at Crawford and having, you know, a chemist in a lab testify and things like that.
Well, I think, Your Honor, we're branching out into what do you do with machines that are producing, and like the chromatograph, right? It puts out some sort of report. You would obviously have a right to say, who programmed this thing? And we see this in DUI cases all the time. You know, do you run tests on this, you know, alcohol sensor or whatever? I mean, it would end up going that route, I think. So you wouldn't have to conform it to the Confrontation Clause, but that's how I think that would work. But again,
so you're saying it would be like a Verizon employee who would say, you know, I ran some tests of the queries in the algorithm that pull these and confirmed that they do typically pull the right phone numbers, that sort of thing. I'm just struggling here because it's not like, I actually think it's a little different than your, you know, I want to, you know, make sure that the breathalyzer is actually working.
Well, I think we have both of them. We have so many levels that who knows? I mean, we just don't know on this record. No one's even contending. There's not even a witness who says the Verizon computer spat this out. We don't have that. You know, then it was copied by a computer. I mean, we don't have any of it. So this, we're all just kind of off the reservation and speculation as to, you know, what actually is here.
Do you think there's any significance in the distinction made in State versus Smith that your friend on the other side mentioned regarding computer-generated documents and computer-stored information?
I think that obviously a stored document can be testimonial, human-created, as with this court's opinions. Whether it's stored or not, I think is an independent question. Those things are stored on computers. There are, you know, a scanned picture of the alcohol printer, alcohol sensor put out could also be stored. I don't think they really overlap. It doesn't, one doesn't determine the other.
So if a detective were to testify that they had contacted Verizon, obtained a flash drive or thumb drive for a computer printout, and what they obtained appeared to be a spreadsheet of a computer printout, why is the fact that it appears to be generated by a computer problematic, or why does it qualify, in your opinion, as something that would be computer stored?
Well, it would be computer stored. I think computer stored is neither here nor there. If an officer got on the stand and testified, I got this thumb drive from this guy, and he made a spreadsheet and it linked these numbers together, and therefore I'm introducing it into evidence. You know, you would say, well, where's this guy? Who is this guy?
No,
right?
I understand what you're saying, but if you testify, I contacted Verizon. I spoke with the person in charge of stored information.
Sure.
I discussed these phone numbers and laid that type of foundation. Why is that?
Because that person's not.
Why would that be testimonial? What is on the thumb drive?
Right.
Why is that testimonial?
Well, we don't know. On your hypothetical, we don't know if it's testimonial or not. If someone at some point, and this is obviously kind of academic to this case, but if someone at some point says a computer spat this out, we don't even have that. Nobody says a computer spat this out. But at some point, if you got back to a computer, at least that level would be okay. It has to be okay all the way down. But I'm not saying that there's not a point at which a computer generates data that is non-testimonial. I'm not saying that. That can happen, but it just didn't happen here, and we don't have a fill-in on those gaps. We don't have a fill-in on those gaps of where this data come from. It's no different from an officer saying some guy gave this to me on the street, and it's, you know, it's an Excel spreadsheet. It looks great, but, you know, we have the right to cross-examine that person.
I guess in a way it's sort of like, you know, I don't have the right hypothetical for this, but it's something like, you know, calling some forensic investigator who's testifying about, you know, there's these footprints in the mud and we examined them and they were made by the person wearing these boots, you know, that sort of thing. And then saying objection, confrontation clause, you need to call the person that was made the footprint, that was wearing the boots. Right. You can't have, and it's sort of, there's something like that going on here where it's just from the perspective of Verizon, it's just this computer generated data. And so I understand the state's position, you have to authenticate it by having the chain of how it got to the person that's going to testify at trial, but right. There's no confrontation clause violation there because it's just you had a court order that said, give us this computer generated data, Verizon complies, and if you want to question whether the data is accurate, subpoena someone at Verizon, you know, that's something that the defendant can do, but it's not a confrontation clause issue.
So, Your Honor, the problem here is that we are going back to some in the cloud who knows what information and scooping stuff up. What if this case, and I wonder why they didn't do this, but they didn't. What if the state had said, we would like the billing statements associated with this, you know, these phone numbers, right? That are automatically generated. They also have a name on them. Like they're using these, you know, all this data to link the name. Why doesn't anybody ever subpoena the billing records? Like there's a name on there. Is it Mr. Lester's? I think pretty obviously not, or we would see it. I mean, the state is either obfuscating or incompetent here. Is it somebody they could run down and associate with Mr. Lester? You know, again, it's pure speculation. That's why, but anyway, in that event, it would be a computer generated thing. We have here, even the quote unquote raw data is conveniently, I mean, you can look at it and tell it's not raw data. It conveniently starts on the first day of the indictment range and conveniently ends on the last day. It's clearly truncated. I don't know what kind of data Verizon generates. I bet they generate all kinds of data. I mean, I bet that the data they could generate would not fit neatly on one Excel page. You know, what the tower was, where it came from. It is clearly a gleaning, a culling of a whole body. Michelangelo famously said, the sculpture is already within the marble block. Before I start to work, I just chisel away the superfluous material. That chiseling away is creation. Michelangelo created the David, right? So just because it's up there and we're taking parts of it, that is a creation. And we need to know if that's from a person and not some automated thing, which clearly, even in the quote unquote raw file too, it clearly was created. We need to be able to cross-examine that person. What were your parameters? How did you do it? Were you copying and pasting? He's clearly doing something.
I just want to note that I've never heard anybody compare phone records to Michelangelo's David.
Well, I'll be here all day. We just have these multi-tiered problems that are starting way before even the exhibits that we actually have in the record 2 and 3. I'd also like to point out, just as a matter of appellate preservation, if you look through the state's brief, they contend repeatedly, that the automatically generated part is the date and time. They never say P-Turkey about the phone numbers, and that's the part that actually they're using to link. So they're not contending in this appeal that the phone numbers are non-testimonial. Look through their brief. Do they say that ever? No. They're just saying the time states, I guess because that's more akin to their cases like the timestamps on the videos or whatever. They don't say the phone numbers are non-testimonial. And this court should not create an argument for them. Turning just quickly to the prejudice prong, I had a wealth of riches at the Court of Appeals. I brought 5 issues. They were righteous. I was mad that the Court of Appeals didn't reach my other 4. So that's why I petitioned for this court to take a look at those as well. This court denied that petition. But their evidence is weak, but it's even weak even if you set aside all of my great issues. The state patently misrepresents the brother's testimony. They put the brother up, so the victim and the brother, I don't know where the father was, they were effectively using their apartment as a drug house and people were coming in and out. So the brother knew this Ray Ray. Ray Ray is the perpetrator. And we're not saying that Ray Ray isn't actually a perpetrator or doesn't exist or whatever. We're just saying Mr. Lester isn't this Ray Ray. So Mr. Ray Ray comes, or Ray Ray, whatever you want to call him. Brother knows Ray Ray. Brother gets on the stand. What question is the state going to ask here, right? Hey, is Mr. Lester Ray Ray? They conspicuously do not ask that question. Brother never says Ray Ray and Mr. Lester are the same person. So that is significant to the identity question. As for the in-court identification that the state hangs its hat on, and one of my issues was that it was tainted because they snuck her in the back of the courtroom, but setting that aside, they bring her in. She stares at him for a couple minutes. She's never identified him before. This is like right before trial. Finally, she says, yeah, I think that's him. But she also says, I heard him talk, and Ray Ray had a lisp and an accent, but this guy doesn't. Also, Ray Ray had a square jaw and was over 6 feet tall. And defense counsel points out, that's not a match. So the identification leaves more than enough room for a jury to acquit, doubting on that identity. And as I've already mentioned, the state's omissions of not doing the obvious things that any competent investigator would do, like, if we're going to link this through the cell phone records, let's just subpoena the billing records. Everybody gets them. They have the names on them. Why not do that? They don't produce that evidence. I think that's a very conspicuous omission. Also, they have physical custody of the phone that Mr. Lester had on him. So if you've got a phone number and you're trying to establish, is this the number of Mr. Lester? What would you do? Wouldn't you just call it? Wouldn't you just call it and see if it rings? Doesn't matter if it's locked, if you can hack into it. If you call it, it'll ring. Do they do that? No. Another just really conspicuous omission. I'd like to turn now finally just to why is this case even up here? Some waiver and preservations issues. Again, as I've mentioned, this whole not a statement theory that they are coming up with, the state not only didn't argue that at trial, it argued a position which was mutually exclusive with that. At trial, the state said, this is a hearsay exception, it's a business record. Well, if you say it's a hearsay exception, you're saying that on its face, it's hearsay. If you're saying it's hearsay, hearsay is defined, Rule 801, as a statement. So the statement at trial said, these are statements, but we can get them in anyway. Now they've turned that all the way around.
Well, couldn't you say that Smith allowed them to do that a little bit, right? Because Smith comes out in 2022. It's reviewed by this court, and we decline review in March of 23.
I think it's a matter of appellate law when you take one position and then you take a completely opposite position on appeal that you shouldn't be allowed to do that. I think it also, even if you set that aside, it bleeds into this whole issue, the main issue here, which is there's zero developed record on this, and that's the state's fault because they didn't raise it at trial. There's also absolutely no argument about the non-statement idea theory at the Court of Appeals. A new assistant attorney general came onto the case, and it was night and day, just a completely different case. The state is the appellant. It can't start from scratch. It can't swap horses. Y'all are all well versed in the swap horses cases. I would also say,
but you are familiar with Justice Irvin's opinion in Baker, where he says that the question on appeal is whether the ruling of the trial court is correct, rather than whether the reason given, therefore, is sound or tenable.
I won't belabor that, and I'll stand on my brief mainly for that, but I will point out that here the state is in the unique position of an appellant. And so it's hard to find a comparable case. But as the appellant, I think they should be bound to what they had prior.
Were they the appellant at the Court of Appeals?
We were the appellant of the Court of Appeals.
That's the same situation that Justice Irvin is addressing there.
I'll just stand on my brief on that one. Finally, also, for this case to be up here on discretionary review, it has to fit into one of the 7A27 categories. This case is a pure fact question, making this court into a fact correction case, really. That's not grounds for review. And also, it's really, it will end up being an academic question, because not only because of my other 4 issues, does this not resolve the whole case, it doesn't even resolve this particular theory of the state's identification. I have a really great argument that wasn't reached about how, so what they did was they said, okay, victim says there's these phone numbers. And then we used the Verizon records to show that there was, communication between these phone numbers. And then they have this, they try to link one of the phone numbers to Mr. Lester. The way they do that is there's a note in the margin of some police officer who interviewed Mr. Lester. In the margin, there's a note there. It just has the number. He admits, I have no recollection whatsoever of that interview. He also admits, I know I had stuff on that my notes that was stuff I got from other cops. Some of it was from me, some of it was from other cops. So clearly it's a hearsay issue. The trial court, sua sponte, not raised, says, well, the exception to hearsay is habit. He had a habit of writing down people's phone numbers. Obviously, habit is not an exception to hearsay. So this is going to die on the other end of that bridge regardless. So for those reasons, I ask that first this court affirm the Court of Appeals, but in the alternative, or maybe even first, that it dismiss this case for review and providently allowed. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. May it please the court. The state has 4 points in rebuttal. Happy to answer any questions that may come up. The first is addressing the defendant's argument that there is simply not evidence in the record supporting that this was, in fact, computer-generated data. And again, I would direct this court's attention to the defendant's brief, where at page 28 he states his concession that the process of how we got to Exhibits 2 and 3 was that, quote, someone at Verizon took its raw data and created a record file. So he concedes that we started with raw data at Verizon. Now, the defense argument is that as that raw data was transferred to the Cary Police Department, as the Cary Police Department then ran it through the PLX program to extract just the information regarding the cell phones associated with the victim and the defendant, that transformed the underlying data into some kind of statement that would then potentially be hearsay, potentially fall under the Confrontation Clause. The state's position is simply that defendant concedes we started with raw data. Merely reorganizing that data or making a copy of that data does not transform it into any kind of statement by a declarant that would fall within the scope of the Confrontation Clause. So as Justice Allen pointed out during my primary argument, the data itself is what matters for purposes of, does the Confrontation Clause apply here? And if we started with raw data generated by a computer, that doesn't fall within the Confrontation Clause, even if that data is then reorganized or the amount of data is whittled down, so long as the data itself remains the same. I would also direct this court's attention to the Court of Appeals opinion in State versus Smith, where the court stated that date and time stamps, so the same kind of information we're dealing with in this case, that's the kind of information that is, quote, purely computer-generated records created solely by the mechanical operation of a computer, does not require human participation. In addition, I would point out that case cited in the state's brief, State versus Hill, 63 F4 335, which is a Fifth Circuit decision. There, the Fifth Circuit also recognized that cell phone extraction reports contain only machine-generated results. So there have been a variety of courts that have recognized that this kind of data, when we're dealing with just cell phone records, that's computer-generated data, There's not any kind of human declarant behind that kind of input of date and time stamps. And the alternative would be that there would have to be thousands of physical people working at Verizon who every time a phone call was made were somehow manually inputting the date and the timestamp, and that just defies reality. In addition, I would direct this court, I'd ask this court to consider kind of the offshoot of defendant's argument that, well, we need someone from Verizon in order to prove that this is computer-generated data. You would need someone who perhaps, as you stated, Justice Dietz, created the computer program to explain how it works, et cetera, et cetera. However, this court has addressed in a variety of cases machine-generated data produced by a gas chromatograph. And I think like the logical extension of defendant's argument is that, okay, anytime the state wished to introduce a result from any kind of lab equipment, does that then require the person who created the lab equipment to show up at trial to testify how this instrument, how they came up with the idea of this instrument, how the instrument was programmed? The state's position is that is simply not required. No court out there has ever required that. And if defendant wanted to bring some kind of doubt into that, to suggest that there were actually human beings who were inputting this time and date stamp data, that should have been addressed under Rule 901 and authenticity, which the defendant did not raise in the trial court, and which, again, the state's, I'll stand on my briefing, but has made an argument that under existing case law from the state, the manner in which the Detective Schneider authenticated the documents was sufficient here. Secondly, although this really hasn't been addressed at oral argument, I just want to remind the court that not only to prove that this information falls under the Confrontation Clause, we're not only dealing with whether or not these were statements by a declarant, but this court also has to consider whether or not this data was testimonial in nature. In Melendez-Diaz versus Massachusetts, the United States Supreme Court explained that business records are generally admissible absent confrontation, not because they qualify under any exception to the hearsay rules, but because having been created for the administration of an entity's affairs, they are not testimonial. So here the data we're dealing with, date and time stamps for phone calls made between various cell phone numbers, that's the kind of data that Verizon records automatically when the calls are made. So that the underlying data, which was at issue in this case, cannot be construed as testimonial because it was recorded or created contemporaneously with when the calls were made and not in any kind of anticipation of a trial. Regarding prejudice, the defendant here and in his briefing directed this court to several arguments he made in the Court of Appeals, which the Court of Appeals did not address, and those include whether or not the victim's identification of the defendant as the perpetrator was appropriate, whether or not the testimony was properly admitted that linked the defendant to the cell phone number in question. The state is not arguing that those issues should not be addressed, but before we get to those issues, I think that the Confrontation Clause analysis provided by the Court of Appeals here in its published opinion is problematic. And again, the relief the state is asking for is not that those issues that defendant raises are not addressed, but rather that this court reverse the Court of Appeals on the confrontation issue for the reasons we've given in our brief, and remand this case to the Court of Appeals so it can address in full his remaining arguments that were pending before that court. Finally, addressing just briefly defendant's appellate waiver argument, Chief Justice Newby, as you identified during my friend's argument in State versus Bakke, 369 NC 586, a 2017 opinion from this court held under circumstances which are virtually identical to those we have here, where the state was the appellee in the Court of Appeals and the appellant in the Supreme Court, that the question is whether or not the result reached by the trial court was right. And here the state argues that it was, that these exhibits were properly admitted at the time of trial, that they were relevant, that they were sufficiently authenticated, and that there was no violation of defendants' either constitutional rights under the Confrontation Clause, nor was there other evidentiary error. For all of these reasons, the state respectfully asks this court to reverse the decision of the Court of Appeals and remand the case back to that court to address defendant's remaining issues.
Thank you, counsel. Thank you both. Court.
All rise. Again.